Hello, my name is Shannon, and I'm a criminal justice student. And I want to talk to you today a little about what is known as the exclusionary rule as it relates to criminal justice. Just want to let you know ahead of time that I did use my criminal justice textbook, which is titled Criminal Justice, the 12th edition, a brief introduction by Frank Schmaliger to help me with this discussion that I'm going to have today about the exclusionary rule. First off, let me just say that the exclusionary rule is basically an understanding that is based on the United States Supreme Court precedent that incriminating information must be seized according to constitutional specifications of due process, or it will not be allowed as evidence in a criminal trial. Um, Based on the Fourth Amendment, the exclusionary rule holds that evidence of an offense that's obtained or collected by law enforcement in violation of a defendant's constitutional rights is inadmissible in a criminal prosecution in a court of law. A little bit of history. That basically just means that evidence that's illegally seized as a violation to your Fourth Amendment rights or constitutional rights cannot be used against you in trial, in court. The exclusionary rule acts as a control over police behavior, which focuses on failure of police officers to obtain warrants, authorizing them either to conduct searches or effect arrests, and especially when they can lead to acquisitions of incriminating statements or seizure of physical evidence that could convict individuals in criminal trials in court. A little bit of history about the exclusionary rule. There was a landmark case, Weeks versus the United States in 1914. Weeks was suspected of committing a federal crime, and he was selling lottery tickets through the mail, allegedly, which is a federal crime. And he was arrested, and federal agents searched his home, and they seized evidence. They did not have a search warrant, and the evidence that was collected did later help convict Weeks in trial in court, and he was sent off to jail, to prison. Weeks' attorney asked that his personal belongings be returned, stating that the evidence, incriminating evidence that was collected without a search warrant, which was, a violation of his Fourth Amendment rights, which made the search illegal. A judge agreed with that and released his belongings. So later, Weeks' attorney appealed, finally making it to the U.S. Supreme Court. And Weeks' attorney basically stated that if the judge already prior ruled that he could have his belongings returned because the search was illegal, then all the other evidence that was collected was also illegal. The Supreme Court basically agreed with his attorney and overturned the ruling against Weeks, and he was released. Some of the exceptions, the Fourth Amendment is the right of the people, just basically to put that out there, is the right of the people to be secure in your persons, houses, papers, effects against unreasonable searches and seizures, and these rights shall not be violated, and no warrant shall be issued but upon probable cause, supported by oath affirmation, and particularly describe the place to be searched, persons or things to be seized. So without probable cause and a search warrant stating, exactly what's to be searched, who's to be searched, what things are to be searched for, and what things are to be seized, without probable cause of these things, securing the warrant, it can be under the exclusionary rule, a violation of your rights. Some of the exceptions to the rule, one is the good faith exception. According to landmark case U.S. versus Leon in 1984, allowed evidence that officers had seized in reasonable good faith to be used in court, even though the search was later ruled illegal. For example, police come to a house where neighbors have reported heavy traffic and suspected drug dealing. Two persons occupy the residence, two brothers. Police ask questions upon arrival and ask the two brothers if they can search the premises. One of the brothers says yes, one of the brothers says no. The police search anyway. Upon searching, police find over 20 bottles of prescription drugs that are not prescribed to either one of the residents, the occupants of the home. They collect the evidence, and later on, the evidence is used in court to incriminate the brother who said they could not search. The brother is found guilty. Okay. So the brother could possibly appeal, saying that, he didn't say that, they could search or whatever have you. However, an example of the good faith is that even though the police searched without a warrant and without that brother's consent on good faith, they searched anyway because one brother said they could, and it was later found that the reports of the suspected criminal activity rang true based on their good faith of what they were going to possibly find at the residence, even though the search was illegal. That's my example of a good faith exception. The plain view doctrine, according to Harris v. U.S. 1968, officers can seize evidence or start an investigation without a warrant based on what they find in plain view and what is open to public inspection. For example, police have a reason to believe certain citizens are fighting dogs and have received such tips from neighbors. The police go to ask questions and upon arrival see a large amount of caged dogs on the side of the home. It's visible from the streets. That's in plain view. Once they get out of their cars, as they're walking towards the house, they see that the dogs are bloody, bitten, malnutritioned. Plain view. So, while walking to the side of the house, which is, like I said, visible from the street, they see more abused dogs around the back, and they continue to inspect. So they can seize evidence or start an investigation, which is if they see something in plain view, which they saw the dogs bloody, bitten, malnutrition as they were arriving at the house and getting out their cars, walking up to the house. They saw it in plain view. So they can legally, by the plain view doctrine, start an investigation, which is to walk further around the back of the house and find more dogs because of what they can already see in plain view. So that's an example of the plain view doctrine. Clerical errors exception, according to Arizona v. Evans, 1995, warrant that should have been deleted from the law enforcement computer database to which law enforcement officers have access. For example, such and such person insurance lapse, say for 24 hours. Okay, so the insurance company sends the notification to the DMV that the insurance is lapsed. The DMV suspends the tag. Within the 24-hour time frame, insurance is gained again on the vehicle. They're legally insured. They know what the fines are. They pay those fines, whatever not, to the DMV online. Their tag is in good standing. However, these transactions occurred so quickly that the law enforcement database, having received the notification from the DMV of the suspended tag, hasn't had time yet to receive all of the updated paperwork or emails, faxes, whatever have you, information electronically from the DMV. and haven't had time to update their systems. So and so goes through a road stop, and the police says, your tag is suspended, and they say, no, I had a lapse of insurance for a couple of hours. I reinstated my insurance and I paid my fines to the DMV online, and I have all my supporting paperwork, emails, faxes, everything right here, officer, for you to see. Well, the clerical error example in this rule is that it was updated in the DMV's database. However, it happened so quickly, the law enforcement database on a local level hadn't had a chance to update their records. So the officer says, I understand all your paperwork looks to be in order. You do have all the right papers and information showing that you are legally covered and that your tag is in good standing. However, I have to go with the information that is in my database, resulting in so-and-so being charged with a traffic violation, which probably is a ticket, driving with a suspended tag, or driving with a suspended tag. That is an example of a clerical error exception, which, different systems have their own time frames which to update information. So information was correctly updated in the DMV database, however, it hadn't reached the local level yet. And that's my example of clerical errors exception. There's one more exception, which is the emergency search of property and emergency entry. According to Brigham City versus Stewart in 2006, certain emergency justify police officers' decision to search or enter premises without a warrant. For example, there's a domestic abuse call by neighbors, and they say we hear fighting and yelling, furniture moving next door. The police arrive. The police have repeatedly been to this address. They're never able to catch the suspected abuser on the premises. However, this time, they do hear yelling, fighting, furniture moving. The door is ajar. The emergency search of property and emergency entry exception is what this example is about. Due to the fact the police have repeatedly been there, they haven't been able to catch the suspected abuser at home. This time it sounds like, the abuser is there, and they obviously hear fighting, furniture moving, crying, yelling, someone asking for help. This would give them probable cause to believe that someone is being abused, and does give them the go ahead. Any reasonable person would say this is probable cause. Somebody's in there fighting, somebody's in there getting hurt. So this would be an emergency search of property, emergency entry exception under the exclusionary rule. So just wanted to talk to you today about the exclusionary rule, how it works, a little bit of history on it. Again, the Weeks versus the United States in 1914 set the standard, the precedent, the basis for the exclusionary rule, which again states that evidence of an offense that is collected or obtained by law enforcement officers in violation of the defendant's constitutional rights will not be admissible in court for use in a criminal prosecution in a court of law. So very, very important that people's rights are not violated while officers are out serving and protecting the citizens. Again, my name is Shannon. It was my pleasure speaking with you today. Thank you so much.